Hey, Exes, I want to introduce Kristen Farris. She is a New York-based divorce attorney. Kristen, thank you so much for joining me. I really want to jump right into it with you.
Thanks so much for having me. I appreciate it.
So I think the biggest thing for me is when someone is looking to file for divorce, what are some things that they need to do to get their ducks in a row? Do they reach out to an attorney first of all? Let's say they're cohabitating with their partner. What are the first steps in filing for divorce, whether it's something that they want to take to court or it's something that they can go ahead and stick to in mediation?
So, when anybody looks into getting either a divorce or a separation, I, of course, am going to give them the pros and cons of everything.
Okay.
There's so many different ways you can go about doing this,
Hmm.
but I always tell clients you want to make sure that you have all your financial documents. If you think that somebody's going to take your financial documents or hide them, or if they get any inclination that you potentially are going to be filing for a divorce or separating or whatever it is, they're going to want to move those so you don't see them.
Hmm.
So somehow, some way, go and get those documents, W-2s, tax returns, bank account information, credit card information. And if they have them hidden someplace, I always tell them, find a way to get them. I don't care how, just find a way.
Go
Because if
digging.
you don't have it and you can't prove it, good luck. It's not going to be like it doesn't exist. And a lot of times, spouses don't want your other spouse to know how much they make because of that financial abuse situation where either one parent's making, or one party, I should say, is making more money. So they're not going to want to disclose the entirety of their income, knowing that they're going to end up paying child support or spousal support or whatever it is. So if you can make sure that you have all your finances put together, you're the first step of moving forward. The other thing is don't move out because a lot of people assume they're just going to walk out of the house and they're going to take their kids. The worst thing you can do is to walk out of the house and try to take your kids because the courts will say your kid's house is the former marital residence. They're going to make sure that those kids get put back. And they're not going to make sure you get put back. They're going to make sure your kids go back. So if you've tried to move out and you've taken those kids, now the kids go back, you've now lost temporary custody per se. And that becomes a huge issue.
Well, and this topic is something that I really would love to talk about because it hits home. I have a girlfriend that was going through a narcissistic, literally, he was diagnosed as a narcissistic sociopath.
Right.
And they were cohabiting together, and she was literally living a nightmare. She found hidden cameras in the nursery. He would, barricade the garage door so she couldn't pull her car in at night. He was purposely trying to get her to move out, to kick her out of the residence. Why does somebody have to live in that environment if it is abusive? Why can't they move out? Can they prove they're living in an abusive situation and the courts will go ahead and then allow them to move out? What can somebody in that position do?
So, if that's the case, a lot of times people will go and file for an order of protection. However, the courts don't like that because it's basically saying you're posturing your divorce case. Because a lot of times people will try and file for an order of protection before they actually file for divorce.
Okay.
And so the courts are like, well, now we know what you're doing because you're going to try and kick this person out so that you can get custody and child support or whatever it is. So I tell people if you don't want that to be the case and you don't want a judge to already have a bad taste in their mouth when you walk in that door, go straight to the divorce court. You should be filing a motion for exclusive use and occupancy and custody and child support. You can file these temporary motions for temporary relief. And by doing that, you're putting yourself looking like an angel to say, look, these are all the things that are happening to me. This is not like I'm trying to get an order of protection. I'm not trying to kick them out just because of one reason or another. I want this court to know it is abusive. This is what's happening, and I need help. And if you don't put that out there, yeah, you're going to be stuck in a situation because a lot of times people were like, well, we want to do this amicably and I want to do it in mediation. Mediation is not a court. Mediation does not have any weight to it until you get a court order. So when you try to resolve cases outside of court, you have nothing telling you what a timeline is. You have nobody dictating what can happen to one person or another. So the abuse is going to continue. A lot of people hate my advice about, well, don't move out. But then they do what I tell them not to do. And then it comes back to bite them in the ass. The
Hmm.
moving out part is so difficult because how many people say, I can't live in this situation? But most judges will not kick the other parent or husband or wife or whoever it is out unless there is extreme danger. And it's not just danger to them, like it's danger to your kids.
Right.
Are they going to hurt your kids? Are they going to kill you? Are they going to, physically hurt you more than just kill you or anything like that? It has to be physical danger. If it's a financial abuse situation, that's easily fixable, I guess you could say, by an
Okay.
order. But in terms of danger and why, like, courts would remove it, there has to be some severe hostility to actually separate the two parties. The courts love to say, stay together while you're getting this done. That gives you the incentive to finish this quicker. That's my favorite quote. Get it done quicker. This just makes you want to go quicker, right? And it's like, but you're not living that life. I'm not living your life. And it's very hard for the person who has to come home every day to be stuck in that situation. So I feel for the clients. I feel for husbands and wives who have to be stuck like that.
Hmm.
But the court and the laws have not been forgiving in those circumstances.
Now, what happens in regards to documentation? I hear divorce attorneys say all the time, document that, keep track of that. It shows a pattern. When does that really ever taken seriously in the courts? Because I feel like men and women that I see documenting abuse, documenting lies, documenting, the significant other going against the court order, I see it not really biting them in their butt. So is documentation a waste of time, or does it depend on what exactly you're documenting?
It depends. And that's
Okay.
like my favorite lawyer answer, right? Everybody as lawyers say, "Oh, it depends."
Hmm.
Because it can go one way or another. Some people become very neurotic about it and they think that every little thing should be documented, like, "Oh, he disconnected the phone, he like hung up on me today." Okay, but did he, like, is that such a big deal? Is it that what's going to get him kicked out of the house, or is that what you're going to use to call him a narcissist? No. If he didn't want to talk to you on the phone, hanging up on the phone as you is not that big of a deal.
Right.
But if he's disconnecting the electricity, disconnecting the cable, putting cameras into hidden spots or hiding it places, that's a different situation. You can do that and somehow either get pictures or you can have somebody at least admit to it in a text message. That's where you're going to want that documentation. But some people will become, like I said, obsessive and trying to do these nitpick type of situations. That's where the courts are going to go, I don't give a crap. I don't want to hear those things. I want to hear the big ticket items. I want to hear the ones that are going to really hurt or break your case. That's what I want to listen to. Not, oh, well, he's not getting up in the morning and I have to take care of the kids today. They don't care about that kind of stuff.
Now, when people want to audio tape somebody either being verbally abusive or videotape some type of abuse that's going on in their home, that is admissible in court, correct?
Depends on the state.
Oh,
So, New York is one of the states where you can record your spouse and your spouse doesn't need to know you're recording them.
wow.
Other states require that both parties need to know that they're being recorded.
Hmm.
So it's a state by state thing. So I don't want to say that every state is like that, but New York is very good when saying, yes, if I record my spouse screaming and yelling at me and verbally abusing me, verbally abusing my kids, videotaping his abuse towards my kids or her abuse towards my kids, that's admissible. So
Oh,
that is always a very good piece of evidence, especially when somebody's looking for more support
hmm.
or looking to
More
have
custody.
an occupancy of the kids
Hmm.
and the house and those type of situations. So yeah, absolutely. If you want more custody, showing the nature of that person, if you have that on audio or video, then it's going to be a really good piece of evidence for you.
Yeah, because I know in California, you both parties have to be,
Yeah. New
un,
York is,
in the know.
yeah, New York is not. New York says as long as one person to the conversation knows that they're being recorded, AKA the one recording,
Right.
then it's admissible.
Yeah, I think New York's way ahead of the game in regards to divorce and the
Yeah.
legalities behind divorce from what I've educated myself on.
In some respect, yeah. I mean, we have, I think that if you ask my clients, they're going to tell you no.
Right.
But I think in some respect, when you compare it to other states, and I hear these nightmares coming out from like the Midwest, and I hear nightmares coming from Texas or the South, and I'm like, wow, I could never imagine practicing down there because of how much leeway we have in some respect up here and
Yes.
how the courts have really changed it to being equalized up here.
Hmm.
Because if you go towards the South or you go towards the Midwest, not everything is equal.
Right.
So up here, it doesn't matter what you have as a married couple. If you claimed it or acquired it while you were married, it's marital property, marital assets. So it's 50-50. And a lot of other states aren't like that, which I would hope eventually they'll come up with the times
Mhm.
because nowadays it's very difficult to not have 50-50 in those type of situations because who can afford to live with no support and who can afford to live with no assets or liabilities or anything like that?
Right, exactly. Well, and I know a lot of the hard aspects of divorces in California too is the fault that California is a no-fault state,
Yeah.
you
I
know?
think for the most part, I think almost every single state is now a no fault state. That
Wow.
is one positive thing.
Yeah.
But before, at least in New York, it wasn't until 2010 that we became a no fault state. I think we were one of the last states to hold out. And
Okay.
the no fault state now just says as long as you've been unhappy for the last 6 months and you've been married for more than 6 months, then you can get divorced. So if one person wants a divorce, you're automatically going to get a divorce, which is great because you're not stuck in what I call purgatory,
Right.
but you can get a divorce, which is fantastic.
Right. Now, I have some friends that are going through some really tough divorces right now where infidelity has been the main reason why they're separating. And it's been infidelity on the man's part. Not to say that women don't cheat. I'm sure that's kind of something that you see now on the rise. But
Hmm.
I'm speaking from a female standpoint and looking at it as the man has been cheating. The documentation of them cheating with, let's say, prostitutes, call girls, it being this like deep dive into this person's lifestyle, can that be evidence as to this person not being best charactered to be a 50-50 father and be involved with the children? Or is infidelity never something that will be taken seriously in regards to issues with someone's character?
That's a tricky question because it used to be years and years and years ago that infidelity was a big part of someone's character.
Right.
Nowadays, the courts don't care. Judges don't care. You could cheat with any person, and the courts are going to turn around and say, how does that affect the kids?
Mm-hmm.
Maybe we put a provision in there that says they can't bring around so and so around the kids, or you can't introduce a significant other to your children within like 6 months of dating them. They don't care as much as the person does on their own. Like they don't care if you're out sleeping with a prostitute or some hooker. They don't care as long as the kids aren't there. They just want to make sure that it's not brought around the children. And this is one of those situations where clients hate this type of advice because they're like, yeah, but you don't understand. My kids shouldn't be around this person. And this just goes to show that they don't have any willpower and that they're just going to go and be with whoever they want. And they
Right.
don't have the best interest of my kids at heart.
Right.
And you're right. In terms of a normal mentality, yeah, you're right. That may be true. But is what they're doing going to physically hurt your children? Because I think the courts are more inclined to see what's physically hurting your kids than any other respect. If your kids are not harmed, what's the problem with them doing it?
Right.
And so infidelity does not really affect custody as much as you'd think it would be doing.
Well, one of the biggest things that I'm thankful for is something called the first right of refusal, which I'm sure you know a lot about.
Mhm.
What is your opinion on, let's say, if you are getting a divorce from someone that you don't trust with your child, would you definitely suggest to your client that they have the first right of refusal written up in their orders?
So, for people who don't know what the first right of refusal is,
Yeah.
we use it here in New York very often.
Hmm.
It's basically saying that if either of the parents are going to be unavailable for their children at any time, then the other parent gets the first right to see their kids before any third person, like a babysitter or a relative or whoever it is.
Right.
So, a lot of times we have to put time limits in them
Mm.
because there are some parents that will use it to the extreme.
Right.
So, like if you had your kids, for example, and you were going to the store, but your kids are old enough to be left at home, does that mean that you have to pick up the phone because you went to the grocery store and you're not watching your kids like eyeball to eyeball? Do you have to go and pick up the phone and call your ex and say, hey, I'm going to the grocery store. Do you want to see them? Like that's extreme, right?
Right.
You don't want that to be an issue, but hey, your kids go back to dad's house and all of a sudden they're telling, hey, dad, mom went to the grocery store and left me home. That's going to be technically a violation that he can say, you're not picking up the phone and telling me you're not watching the kids. Or is it where your kids are now at an age where they're wanting to sleep over at their friend's house or they're going to be with their boyfriend or girlfriend and they're getting older and they're going to school dances and are those circumstances where that first right of refusal should kick in? So we need to put specific parameters. I personally tend to tell clients like a 3 to 4 hour time frame is probably best. Like
Hmm.
if you're giving your kids to aftercare and you're only going to be gone for an hour and you're not getting your kids until 5 o'clock instead of 4 o'clock, that might be a situation where you're like, why do I have to call dad every time and say, hey, do you want your kids from 4 to 5? Because I can't get to aftercare till 5.
Right.
That to me sounds like a waste.
Right.
But you have to be realistic. If
Hmm.
you know the other spouse is never around your kids
Hmm.
and they're never home for them, or they're never being or doing things with them, and they're always with their grandparents, or they're always with a babysitter, or they're always with the girlfriend or boyfriend, then maybe that's where you fix that provision to be what your circumstance is so that the kids are known that they're with a parent. They're not always with a third party. And you, as the parent, feels that you're given the opportunity to spend more time with them than not.
Right. Yeah, no, I know a lot of my friends have the 4 hours. They have a 4 hour
Yeah.
first right of refusal. And the only reason why they went ahead and put that in their orders is because they left when their children were infants or toddlers. Now, I'm
Yeah.
assuming at some age, a child is going to possibly outgrow the first right of refusal as they
Yeah.
become preteen and teen. So I'm assuming that's something they'd have to go back to court to change and update.
Potentially, unless the two parents are agreeable to like modify it themselves. Like if you and your co-parent, and I say co-parent because that's the expectation, but if you and your ex can have this co-parent relationship where you can literally text each other and be like, hey, Sarah wants to go to so and so's house for the night. I'm letting her go. Just wanted to give you a heads up. That should be fine because the other
Right,
parent should be like, oh, my kid's 13 or 15 or whatever it is. That's no problem because they're not going to want to spend time with me.
right,
Teenagers do not want to spend time with their parents. They
right.
want to be social. They want to go to events. They want to go to their friends' houses. So you as a parent have to understand this strict interpretation of your agreements should become a little bit looser as they get older because they're going to have more of a say anyway. If you wanted to go back to court and violate these parents who, oh, they didn't pick up the phone and call me because Sarah went to her friend's house for the night. So that's a violation of the first right of refusal. They're again trying to, I claim, to harass you because they've got nothing better to do and just bring up silly things, or they're not understanding that their kids have certain rights too.
Right.
And they have rights to be a kid. And being a kid may mean being social or going to a friend's house or doing certain things. But if you're not co-parenting and discussing it with the other parent, that's where you're going to see a lot of these problems.
Now, something that a lot of my friends didn't know about that I actually suggested they do because I found it super helpful is using the parent talking apps. If you're going through a high conflict divorce, is that something that you suggest too, whether it's like OFW or I think there's another one that I can't think of right now?
So we use about three of them here in New York. I mean,
Okay.
I've heard so many of them, but the three top ones that we use here in New York are Talking Parents,
Hmm.
Our Family Wizard, which
Hmm.
is the OFW, which you mentioned, and then the other one is called App Close,
Okay.
which seems to be more popular towards like northern New York and up above the city area. So where I am, we're right outside the city. So we tend to use the Talking Parents and Our Family Wizard, and I think they're a very useful term. And I
Okay.
should be getting a plug from Our Family Wizard because I promote them all the time. But I think the good thing about them is, well, I call them they're non-manipulatable, which
Right.
means that you can't go back and change what is said. You can't go back and change the timestamp. So if I send you a message that says something about our kids, it is timestamped of when I send it. There's a read receipt stamp as well. So if you don't read it for 4 days because you just didn't want to, it'll show that.
Hmm.
And then I can't go back and change what I said to you. So if I call you all these names in it and you want it to be subpoenaed, for example, it's going to be there. You can't go back and say, oh, I never said that.
Right.
The other good thing about these apps, and they're getting better as time goes on because I think a lot of courts are using them as useful tools,
Hmm.
they can do recorded FaceTime basically. So it can all be recorded so you can document what these parents are saying to your kids. The other thing is that it's subpoenaable, which means if I said to my client, hey, I need those records for trial, go and ask OFW for a subpoena. I'll send it over to them, or they just have to certify it for me so I can admit it into evidence. All they have to do is pick up the phone, call OFW, and say, I need these to be certified for my attorney. I get it within a week. And I
Wow.
can submit it as evidence, and it's all admissible because they're considered business records.
What about emails or text messages?
So those are good too, as long as it's with your other parent. If it's not with the other parent, then it's not admissible because it's hearsay.
Mm.
So if you're talking to your mom and you're talking crap about your ex to your mom and you're like, oh, I want to show that I told my mom that this happened, but I don't have a text with my ex about it, it's hearsay. You can't admit that. You can only admit certain things that are they're called out of court statements.
Okay.
So if they're made out of court and they're not based on you and the other party, you can't get those in.